to add on there.
Yeah, the last one was we had the most. We beat our record for how many people watched that one.
We did?
Beat our record for the last meeting, not the last meeting. The
My family tunes in if I'm not home right after. They're like, where's Dad?
oh dear.
Please tell me I have my glasses. Please tell me I have glasses.
Whenever you're ready, Scott.
No glasses.
Howdy.
Go ahead.
Thank you. Good evening, everyone. This is November 3rd, 2025. The time is now, just going by the clock, 17:48. And this is the meeting of the Charter Review Committee. And I note that all of our current members are here, present, and bright-eyed and bushy-tailed and ready to go. The first item that will come is our opening of the meeting. I declare the meeting open by means we have obviously have a quorum. And the very first thing that we'll ask to do is to review, revise, reject, or accept, or whatever, the meeting minutes from November 3rd of 2025. Did everyone have a chance to read them that were sent out by Paul?
Yes.
And Chuck?
Yes.
Okay. Does anybody have anything they want to say about them in terms of accepting them or making any changes, modifications, or revisions, or corrections?
Point 6, there was just a date. It was just, next meeting is November.
Okay.
Very
That's-
minor change.
Okay.
Eagle eye.
I love to have people. I think I said to somebody that I always make one typo in everything I type, so it's probably more than that. But
Everybody does.
okay. That being said, Paul will make that notation for a change. Is there anything else that needs to be said in any way, shape, or form about the minutes? Oh, are we ready to take a motion to adopt?
Move to
Motion
adopt.
to accept the minutes.
We have a motion,
minor
a second.
change.
We have a second. All those in favor?
Aye.
Hi.
I agree, and there's no one opposing, so we shall adopt those meeting minutes, and with that one date correction. For the record, we have two distinguished residents and officers of the town of Paxton. The first one is the chairman of the select board, who will be is attending and has attended several of our meetings in the past, and is always welcome. So I'd like everybody to take a smile in that direction. And then we have another significant member of the Paxton municipal government, and that is Town Administrator Robert Birkbeck, who is here. Thank you.
Thank you.
Do either of you gentlemen have anything you want to address us about at this point, or shall I?
Not right away, perhaps later.
Okay.
I'd also like.
I guess he got the advanced copy, huh? Robert, anything for you?
No, I'm good. Thank
Okay. Because we are trying to get into the language and everything else, I'd like to spend most of our time today in our meeting to go over the several of the articles that we're working towards finishing and ultimately to compile a draft charter. But the first thing that I will ask, Megan and Chuck, you guys both mentioned the visual aid for the 10 November 2025 chair update. And it is my understanding that that has been completed. I did get a copy. I found it very nicely done. It's certainly great. And I believe it's all ready to be presented with the town administrator going to actually work the keys and all that sort of thing so that we have that. And to accompany that, I'll just give a brief response and summary and little additions like that. And then we'll all be here for questions and answers, either to or from us, to the select board, because we have 15 minutes allocated to us for our status report, which is a little late coming, but it's about time we got to attend it. So there's nothing to address on that because that's already set. Megan and Chuck also have been talking to us about the formatting a standard, consistent style. And Megan, I'd ask you to just give us a brief status report. I'm not asking you to give us a document or anything like that, but you are working on that?
I am. I haven't started it yet, though, but I am
Okay.
going to work on it. One quick question on the visual aid or the PowerPoint for tonight. Did we come up with our number that we were requesting of the Finance Committee? That was my only outstanding question that I don't think got addressed. So we're ready for tonight?
Well, I always thought that the one that was originally on there was perfect.
3,000?
Yeah, but I think then there was some research that I was just dreaming in the sky, and it wasn't
Oh, it was
close.
2,000,
It wasn't
sorry.
3,000, it was,
Okay.
go ahead, sir.
I'll go back and verify, but I believe it was 2,500.
Which is pretty close to 3,000, but, that's how much we had asked, and it was something that got through the Finance Committee, but obviously when the Proposition 2.5 situation in its first iteration didn't come up the way they wanted, and then ultimately the
Yeah.
second iteration, understandably, we were not on the budget. In the budget, there was nothing. I think we're going to need something in the budget, and maybe they'll be asking us questions about that at some point in time, maybe even tonight. But no, we've indicated we want something in the PowerPoint that will be broadcast later that does ask for an amount, but no, there is no number sign put to that at this point because we're at the mercy of whatever, if anything, that the powers that are
Okay.
in the budgeting process might find that they could squeeze out of somewhere for us.
Okay.
All right. So that being said, does that take care of the question on that? It takes care of the question on the formatting guide. We all prepared to start talking about some proposed draft items. The specific ones that are on the agenda for tonight are the charter provision relating to enforcement of the charter provisions. The next one is glossary and definitions. And then the next one after that would be exercise of legislative powers. I'm not necessarily expecting that we'll get through all of them, but I'd like to make a dent at least 2.5 of them. So with that matter, I will proceed to ask for people to tell us if they're ready to discuss what's labeled in my draft here as the outside section entitled Enforcement of Charter Provisions. Any comments on Section 1, General Enforcement?
No.
Okay, and are we ready to accept that then, in general, or as we move on to Section 2? Okay, Section 2 is entitled Additional Remedy, and I will tell you that basically derives from only one charter of the 50 that I reviewed that has that section in it. I modified it a bit because looking at it from a collective bargaining perspective or anything like that, that may not fly. And so I made a modification to what the original that's in somebody else's charter. So if we all read that and offer any comments, criticisms, whatever they have to say about Section 2, entitled An Additional Remedy for enforcing the provisions of the charter. Megan?
It was more on language, depending on who reads this. I wasn't clear on what the doctrine of,
Stare decisis.
yeah, I didn't know what that was.
Yeah, I
So I didn't know
hate
if
to
we
say
needed a
this,
little
but
more layman terms than
yeah,
that.
that's
there.
a legal term which I would like to tell you wraps it all up, but it's not something that's in common knowledge. And
Yeah.
frankly, it's not something that we need to, I'll tell you what it means, and then we need to kind of figure out how to put that in human being language rather
Yeah.
than lawyer language. So that being said, I'll put that on the hold for a minute, and I'll ask Paul, do you have anything to say other than the doctrine of stare decisis is something that you don't want to stay? Gary?
I have a suggestion to changing that sentence.
That would be great. How would you like to change that sentence?
So, the sentence begins with the filing. I would like it to read, "The filing, acceptance, review, and response to any such complaints shall be administrative in nature, restricted to matters within the scope of town operations, and shall not be considered or used in any subsequent litigation, period.
Any subsequent litigation, okay. What Gary has done is in a very nice format, and I'm inclined to say that that says it all. Stare decisis is a legal doctrine. It basically says that if a decision has been made, that decision applies to all similar situations.
Okay.
So that's why, for instance, you may have read the things about, I don't know, SNAP things, and one judge says they have to, the executive branch of the United States has to do this, and another one in another circuit might say, no, they don't. Well, you can't have stare decisis there because they conflict. But in a case where there's only one court that has made a holding, that says that will be binding on all the other courts unless they specifically decide to amend it or whatever. Now, in this particular case, the reason why I use that doctrine in there, and I put it in there so that I wouldn't have to type all of the stuff that Gary just said, because the bottom line is, what it says is that anything, if this particular remedy is exercised by any citizen who feels that somebody in the town, as an official or government body or entity or whatever, does something that they feel doesn't honor the charter requirements, the provisions of the charter that tells them they can do this or they can't do this, then they have a right to make a complaint. And then it gives a little bit of a process, which is in there. And but we don't want anybody to think that somebody who is aggrieved by that, doesn't like that decision, can go to a literal judicial branch court as opposed to an executive branch committee, which is the select board that we're talking about here.
Okay.
And say, we don't have to litigate this. The select board in the town of Paxton is already.
Okay.
Okay.
I
Does that
think-
make sense?
Yeah, maybe we just need to repeat it one more time, so.
Yeah, so
Okay.
I would put a comma after the word nature, and then it reads, restricted to matters within the scope of town operations and shall not be considered or used in any subsequent litigation.
Chuck, anything to say?
No, I'm not even going to say it. I like the change from that.
Okay. So I guess we're all ready to accept that change and move on to Section 3, which talks about the requirements relating to that remedy. The written complaint that would be filed by somebody who is aggrieved shall state the specific act or inaction of the alleged violation, provide the name of the officials or municipal bodies involved, provide the dates and times of the alleged violation, and enforce, specify the applicable charter articles and sections that they feel were not carried out according to when they were intended to be. Is there any reason anybody needs to make any changes or thoughts or clarifications on that? Moving on then.
May I ask a
Accept that.
quick question, Mr. Chair?
Yes, sir.
Why did you, and I wasn't here, so I apologize, but why did we make this Section 3 rather than Section 2 continued? Because it seems like Section 1 is one remedy, Section 2 is another remedy, and Section 3 actually is a continuation of Section 2.
Well, Section 1 is the general enforcement.
Correct.
That's one that's in every charter.
Right.
Okay. Section 2 is an additional remedy, and that's the remedy that if you have Section 2, then you have to start talking about the process.
I understand that. So, but if you have Section 2, isn't Section 3 just a continuation of that? That's the process that goes with Section 2?
Well, it could be unless somebody wants to, see, this is for drafting now. This isn't for how the actual charter is going to ultimately come to you.
Okay.
This is for us to draft it. So if somebody wants to make a change, we can parcel out, well, Section 1 is the remedy, Section 2 is the requirements of the complaint, Section 3 is filing procedures, Section 5 is the responses to written complaint, Section 6 is the procedure for notification to the complainant, and Section 7 reiterates that it's a public record. We ultimately can have one section that says enforcement, but breaking it apart in different sections makes it a little bit easier, as in law, The laws sometimes, especially in Massachusetts, tend to have, 37 pages with only one section. I broke it out. If the committee ultimately
Okay.
decides, or the select board ultimately
No,
decides to
that's
have.
fine. I was just curious. That's
No, and it's a good question, and I'm always good at cutting things up into pieces anyway, so. Anybody else have anything to say then, or questions regarding this section 3?
No.
Okay.
Should we, well, I just have a question. Should we have a spot for them to, names of witnesses or names of, like, something to corroborate it? Like,
Well, that would be into in the concept of writing up the requirements, okay? And I would say that we don't want to talk about witnesses, because then we get into the idea, well, they have to be sworn, and then we have to get somebody who can take an oath. That would be a commissioner of oath. So that means we'd have to get another official, and I don't believe the town of Paxton has any commissioners of oath, so we'd have to go to another agency to get
well,
some.
maybe witness is the wrong word, but should we have, like, just somebody that can corroborate it, right? Because
Anything that they have to say, this is going to be done all on paper. I'm not contemplating a hearing unless the select one decide to have a hearing in response to the Section 5 proviso. But this would be, they would have to make a full statement, and so-and-so saw this, and identify them, and then the person who is being complained, or the board that's being complained, could say, hey, do you have anybody that we can talk to that, so but that's all done in writing. I'm not contemplating a hearing for the initial stages of that. The bottom line is, once the complaint is sufficient and satisfied and a decision is rendered, then it gets into the quote-unquote litigation stage before the select board, if they don't like okay? Filing procedures. A person who is aggrieved shall have 60 days from the date of the alleged violation to file their written complaint. They will file it with the town clerk, who will then send a copy of the written complaint to the town official and/or municipal body chairperson, the town administrator, and the select board. So the select board will be notified, as will be the alleged miscreant, or, the guy who made a mistake or whatever. And then there will be a response period, which is in Section 5. With respect to the filing procedures, then, as just stated and as appears here in Section 4, any thoughts about changing that or modifying that or clarifying that?
I just wanted to define the town official or municipal body chairperson as something different.
I'm sorry,
I
say
guess-
that again?
How would they know who the municipal body chairperson would be?
Well,
Is that
would
sort of
be
the chair of?
They would, if they have a question about who because like municipal body is going to be, say it's our board, somebody doesn't like something we do,
So they would go to
they
you.
would send the chair, and they would look it up on the website, which
And the
says-
town official is different than the town administrator or the select board?
The town administrator is sitting right there. He's obviously not the.
I meant
you know.
more the town of, you have two.
Yeah,
You have the town official and the municipal body chairperson and the town administrator.
No, it's,
So I just thought,
Yeah.
is it one or the other?
no, it's the town official who is being, Section A is the town official who allegedly did something wrong. Okay, so say I do something wrong,
Oh,
which is highly unlikely.
so maybe it should say the alleged town official?
No, they're not alleged. The town official is the town official is the person that's going to get, these are the people who the select board, the town clerk is going to say, okay, I have this complaint from, I don't know, Jane Doe from,
I think her point is we need to say the town official involved or something like that, because it just seems like the town
yeah,
official.
okay.
Yeah.
That would be, okay, that would be,
That's what I'm wondering. Is
Yeah.
I
who
get
is
it. So
the
you,
town
would-
official?
to the appropriate town official, the involved town official, which one would you like, appropriate or
I would say we
think
use
involved.
involved up here, right? So when they do the written complaint,
to the town
provide
official?
the name of the official or municipal body
Yeah.
involved. So I think we use that same language.
Okay.
Yeah, that works. Okay, that's clearer.
Okay, I love it. And/or the municipal body chairperson, I mean, if it's,
That's
the town
also-
official would be the appointing authority. That would be in the case of somebody that's appointed by the town administrator, he would potentially get two as opposed to one, because and the town administrator is on there anyway, and the select board. So the select board will be clued into this whole thing formally right at the very beginning of the process. They won't be acting at this point, but they will be aware of this.
Okay. Yeah,
Okay.
that was my only one.
And then the next question will be Section 5, what happens after the written complaint has been filed and disseminated to those people? And that states, as you can see there, and within 30 days of receipt of the written complaint, the alleged offenders and/or the municipal body chairperson shall file a written response to the town clerk, town administrator, and select board. The response has two options. It can, A, acknowledge the alleged violation and suggest a suitable remedy, or B, deny the alleged violation and provide a written statement of reasons in support of the denial. So the person that is supposedly done something wrong, as well as the committee chairman, or they will get together and say, hey, I made a mistake. Here's how I propose we fix it. All right? Or they'll say, I did make a mistake, and here's why, and let's tell them to, we're not going to do anything. Upon receipt of that response is the next paragraph. The town administrator and the select board shall have 15 days to review the written response of the alleged miscreant, all right, and decide by a majority vote whether they will accept the admission and proposed remedy. In other words, they'll adopt whatever the person suggests is done.
I'm getting confused, 'cause I feel like you're adding words in that aren't here, so you're just editorializing?
What are we talking about? What words?
So you just said the town, you're not just straight up reading it, you're adding words into it that aren't there.
Well, now I'm explaining it. Upon receipt of the written response, the town administrator and select board shall have 15 days to review the response and decide by majority of vote whether A, accept the admission and proposed remedy, and/or B, accept the admission and modify the proposed remedy. Okay, so either, and this is an editorial, which should be fairly obvious,
Should I add in and/or?
to accept the admission and modify the proposed remedy, or accept a denial and statement of reasons as figure it. So in other words, as that paragraph says, there are three options for the town administrator and select board to respond to the response from the person that was accused of violating the charter. Okay?
I have a few comments on this.
Please.
Yes, okay, so one is super easy. I think it's grammatical. In the first paragraph, right after written complaint, I think you need a comma there. At the first, yep, that one.
In response?
One up,
First line.
first line.
Oh, got it.
Yep, and I think you need another comma right after second line down, after chairperson. My feedback
sorry.
on that
I just-
second paragraph is I felt that 15 days was a little aggressive for the town to meet and come together. I don't think that's realistic, and if we set that precedence, I don't think it'll be followed. Not
Well,
because
That's what
it
I
won't
was
be.
thinking, why we have 30 days
I
for the
d- yeah,
first part and then
yes.
15 for the second.
And you don't meet frequently enough, I think, for 15 days to be realistic. That's my thought.
What do you think that 15 days should be?
Well, I don't know. I would ask those that would have to do it.
Mr. Town Administrator, sir.
I mean, if you're giving 30 days to that first section, I would advocate for 30 days for the response as well.
Okay.
Because we have to vote, we have to do everything.
That
I'm just
was-
following what's known as the halves rule
Yeah,
in legal options, is that the person that gets to decide whether what's already been written, because they don't have to write something, they just have to decide, I like this, I don't like it. I would like it better if we don't give them $50, we give them $100, or I give them
Yeah.
$100.
Well,
But-
thank you for your rationale behind that.
That's all, but it's
Yeah.
not 50 days, 15 days it shall be.
I almost thought 60
I mean,
days
30
might
days
be.
it shall be. I'm sorry?
I almost thought 60 days could potentially be more realistic because
You don't have
they
60
have
days to file a response on a criminal complaint, so. I
no,
mean-
but I'm just looking at the way the town operates, and they have to still meet and vote. And I don't know if 30 days gives them enough time to do that. I don't know.
Okay.
I'm asking.
What do you think, Peter?
Well, my concern would be something that comes forth during the summer. So if we were to receive it on the Friday or the Monday of our July meeting, 30 days is going to be cutting it tight.
Okay.
It wouldn't make the July meeting,
Yeah, that's what I was thinking.
especially during the summer. The rest of the year it wouldn't be a problem, but during the summer, it definitely could be.
Okay, without having to meet on
Yeah.
one off.
What about 45 days?
45.
Going once, 45.
Because 60 sounds like a lot, like a,
Well, the thing is, you don't have this lying around. I mean, you
could
just
be
don't
up
want
to-
somebody trying to get something resolved and having it sit for too long. But 45 days, I'm not ever been on a select board, nor do I ever intend to be. So the bottom line is, I don't deal with, this stuff. I just have a situation where the judge tells me, or, my boss tells me, you got to get this done in 30 days, 15 days. Those are the kind of the rules that we have.
30 would be fine.
Because it's that extreme situation of July,
Situation.
it would have to fall on
And
a
the chair
certain
can
week.
call a special meeting, so I would think 30 days gives you enough time, so that it's not sitting around too long. I agree with that. 30 is
You want to
fine.
be responsive back to
Yeah.
Yeah.
individual
Yeah, I think 30 days is
allegations as
fine.
well as the person who's being accused.
Okay.
Yeah. And then you're giving the same amount of time to each party.
Okay, so 30 days?
Yeah, I'd keep it at 30.
Does everybody agree for 30 days?
I agree to the 30 days. I still have another change on first paragraph, though.
Okay.
Is there a reason why the individual who's making the allegation is not getting a copy?
Because they're the ones that wrote it. When I'm talking about the response of
There's a written response being given to the town clerk, town administrator, and a select board. It's not being given to the person who filed the complaint.
Yeah, this is the response he's talking about.
right, but we haven't, they're getting the written complaint, and they're getting the, defendant's version, and they don't want, that hasn't been decided. You don't want them to say, hey, the guy who did it said he would pay $100. That's not what we're talking about here. We're getting something fixed,
I see
not
what you're saying,
paying
though.
money. This is not a punitive thing.
Yeah.
Right? Then it has to go to the select board to say, we like it, but we accept that there's a responsibility there. We expect a rationale for the responsibility. Now the question is, do we do what you asked us to do to mediate this thing, or do we recommend something else, either something more or something less than what you suggest?
But
And then once that's decided, that will go to the complainant. But it's part of the whole litigation process, if you will. This is litigation in a sense. So the idea of this is, you don't want to tell them what you're, it's like a meeting between okay, so what are we going to do? We're going to accept this, we're going to say 30 days.
I think he has that part. It might be the title of the section.
But you're talking about transparency in this whole document. So if I am a resident of the town and I'm filing a complaint on a charter violation, then 3 different bodies gets a copy of that answer, but not me.
Well, it is a public record. That would be something that would be, unless otherwise provided by laws of, it is a public record, so
Yeah,
they
I
are
don't-
entitled to request it as
I
a
don't
public
see a
record.
downside of giving that copy at the same time that you're giving it to the public body.
Okay, within 30 days of receipt of the complaint, the alleged offenders and the municipal body person shall file a written response to the town clerk, town administrator, and select board, and complainant?
Yeah.
Okay. Everybody agree?
Yeah, that sounds good to me.
All right.
Complaint.
And you're adding that? Okay.
Yeah.
good.
Is that how it reads, complaining?
I also have a concern on paragraph 2.
Okay, can we just get through this?
Yeah.
Make sure, I don't want, Chuck's trying to type this in here.
Chuck's good.
Complaining, did I spell that right?
Yeah.
You don't need a comma, sorry, Chuck, after chairperson. That's incorrect.
So the first paragraph in section 5 is that we've added the complainant as somebody who gets the response. And then we have the commas.
We took out one of them. Megan just took.
Yeah, I just took one.
Yeah, okay.
Yep.
And then we have the second paragraph. So are we satisfied with the modifications suggested to adopt them in the first paragraph of section 5? Yes, sir.
Am I reading it incorrectly, or I like the idea of them getting a copy of that, but doesn't it look like they're writing it to themselves?
Well, it's a receipt of the written complaint. They wrote the complaint, so they're not getting it themselves.
Well, correct. So that's what I'm just asking. The alleged offender will file a written response to the clerk, administrator, board, and complainant, which is,
Okay, I'm not sure that this is something that the clerk would respond to. I think that it would be my original thought in this was to give the select board the ability to negotiate in public with their miscreant to get
Oh,
it
absolutely.
before it went out there. But if you're
Yeah.
going to send out, this is what the miscreant says, that we're going to put a situation where maybe the miscreant should draft their thing.
But in that situation, if I was the one that was proposing I owe $100, right? So I'm writing to town clerk, town administrator, select board, and myself.
No.
This is from
Back too,
the
right?
person who's been accused.
Yeah.
They're sending it to the person who accused them.
Okay.
So if you were being accused of doing something wrong, you're following
Okay. Thank you.
your
In the
answer.
complaint.
accused,
I got
yeah.
it. Thank you.
But-
I appreciate the clarification.
But may I make a suggestion?
Please.
That the written response go to the town clerk and the town clerk distribute it to the town administrator, the select board, and the complainant. Because as someone who's trying to respond may not know how to get it to the complainant, if they just respond to the town clerk, let the town clerk make the distribution, I think that might be easier on everyone.
Okay. The municipal shall file a written response to the town clerk,
Who in turn?
who in turn, okay. And so upon receipt of the written response, the town clerk shall forward,
Yep.
okay, can we have how that works out on language? I love this board. This is wonderful.
Does that do what we wanted to do?
Forward to the town.
Yes.
Yes. Who in turn will forward it to the town administrator. I mean, keep in mind, we're not in law here yet. We're not locked into this. This is a draft of a proposal that ultimately will be codified in a whole draft proposal, and then everybody and his uncle will get a chance to look at it in our, and all that. And plus we need to have formatting once we have that adopted a formatting process.
Well, I'm holding off on any style and format comment.
Yeah.
Yeah.
Go farther down that road.
Okay. Okay, so Gary, Paul, all set on the first paragraph?
Yeah.
Chuck
Looks good.
and Megan? all
I'm good with the first paragraph.
I love, this is really the way committees should be financing, operating, I think, on these kinds of things. Gary, you mentioned that you would like to see something different in the second paragraph of Section 5.
Yeah, the words admission.
I'm sorry, the word?
Admission appears twice. And it has the potential to have a legal meaning, and I'm trying to avoid that. And
Okay.
I rather use the word acknowledgement.
Okay, I love it.
So A, accept the acknowledgement and propose remedy, and B, accept the acknowledgement and modify it. Because you use the word acknowledge in the first paragraph.
I love it. Okay. Everybody understand what Gary's saying and
Yes.
have any comments, objections to that?
Yeah, it was a good one.
Paul?
Looks
Chuck?
good.
Got it.
I agree. Acknowledgement is a much better word than admission. Any other suggestions, complaints, or criticisms, or revisions, or whatever we could say?
Do we need in here, depending on the seriousness of the accusation, do you need any legal counsel review added to this process at all?
That'd be up to the town.
That's up to the select
That'd be, we wouldn't, I mean, if the select board wants to consult, they can
They'll do it on their
consult.
own.
If they think they
Okay.
should. I mean, we're talking about a charter,
Okay.
okay, and it's not, there's nothing in there that's going to provide for, I mean, if you violate the charter, you're not violating the charter by, and you're not going to pay them off with $100 because, I don't know, we got something, I mean, keep in mind what the charter's going to have in it for contents. In any event, I mean, I'll just say that so far, I've only found one group that had this, and it was written in such a way that nobody with a contract would allow it. And the bottom line is, I think it's a good thing to have, but it has to be, but
Okay.
we're gonna make it too complicated. All set on then
All set.
paragraph 2, section of 5.
Should there be a comma after the word response in the first line?
You can put a comma any way you want.
Upon receipt of the written response, comma, the town administrator and the select board shall have.
Yeah.
Okay.
Yep.
And is everybody satisfied with the proposed, or the amendments to that?
So just walk me through the process for a second in that section. Upon receipt of the written response, the town administrator and select board shall have 15 days to review the response.
Well, we can eliminate one or the other, or leave both. I'm encouraging the town administrator, as I will.
Yeah, you're right. We should choose one person, not two.
We should, but I mean, I just want to make sure that the town administrator is somehow involved with the select board at the get-go, or, I mean, it all depends upon how much power and authority the town administrator is going to be given. If the town administrator is the only one, or the select board's going to be the only one, I mean, you would think that there would be such a working group thing between the two that it wouldn't make any difference. The administrator would obviously say, this is what I'm thinking, what are you thinking?
Right, but you have it in the language, you have by a majority vote, which implies that it's going to be done by the select board.
That's right, because the town administrator doesn't vote on anything. They have an opinion.
Yeah, but it doesn't read right if you're having both of them there. They're both going to review it and then decide by majority vote. It's got to be cleaned up, I think, a little bit.
Okay, upon written, do you want to leave town administrator in there? Let's start with that. Do you want to leave town administrator in there or remove it? What does everybody think?
I think in the end, the select board is the one that's going to make the determination. It takes away some of the politics involved if the town administrator doesn't, and they will direct then the town administrator to do whatever it is that they have to do. But I think
All right,
it's a select board decision.
You propose then that we say, upon receipt of the written response, the select board.
Shall have 30 days to review the response and decide by majority vote.
Okay, if we do that, should we then revisit Section 5, the first paragraph, which shall file a written response to the town clerk, town administrator, and select board? Do we want them to file the complaint directly with the select board?
No.
No?
Okay, so we want it to go to the town clerk for administrative purposes, to the town administrator for whatever. I mean, I have it as a, and
I think I would definitely want
Want to be
to
involved.
receive
Okay.
that.
Of course.
And
Even though I'm
okay, so
not
that doesn't
voting
get
on it.
changed, okay? So we're going to say, upon receipt of the written response, okay, the select board shall have 30 days to review the response and decide by majority vote whether to A, B, or C. If we make that change, that good,
I think it's cleaner.
sir?
Yeah.
Yeah, I like that.
Yep.
I think that makes more sense.
Yep.
Yeah, absolutely.
This is fantastic having the two of you guys here, I'll tell you. I wonder what they would like. Let's see if somebody will tell us. Okay, Paul, anything to say? Or Megan, anything to say about the second paragraph as
Nope.
modified?
No, that's good.
Okay,
Love it.
there we go. We are now ready to move on to Section 6 of the article. You know, it's Section 6 of article, whatever it's going to be.
Yeah.
Notification to the, or shall we say final notification to the complainant, because they're going to get two notifications. They're going to be at one or whatever. So does anybody want to agree or disagree that we should change the title of Section 6? Should that be final notification?
Is it, do we need to imply decision or final decision to complainant?
Okay, final
yeah.
decision?
I think that's what we're saying.
What would be better? What would be a better title for that?
I don't have legal,
Decision, resolution.
but I
It
think,
says select
I feel
board
like
decision
decision.
below it,
Oh, yes.
right?
See where this is Section 6. The last, within 5 days of the select board decision, the town administrator shall provide the complainant with a written statement of the decision by registered mail. Anybody have any, we're just talking to the title. Does it, final notification to complainant, does that do it, or do we want to change the title?
I think decision is more specific. I think decision is more specific.
Well, we got the word decision in the text. I'm just talking about the title.
Yeah, yeah.
Yeah.
But I think I agree with Megan saying they're not just being notified. This is the resolution.
Or maybe that's the word. Maybe is it final?
Well, you know, it really isn't the resolution, because under equity law, they can go out, they can go someplace else. So that may not be the final decision, but this
Okay.
is the final that the town's going to do.
Okay.
So it's
Okay, then I can get
notification.
behind it. All right.
I mean,
Yeah.
you can't go beyond your scope of authority.
Okay. It's not big enough for me to sway one way or the other.
I do believe the word final, though, should fit in there, so that
I
way they
think
know
so,
that that's the end of that process.
I think so too.
Yeah.
Okay, so we'll say final notification?
Yep.
Everybody agree?
Yep.
Okay.
And then in the paragraph, I would consider changing the point, the town administrator, to maybe the town clerk, so it's consistent with the point of contact for all the other work.
Everybody have a thought on that? Anybody
Yeah,
have a
I'm on board with that.
town clerk?
I would put a comma after the word decision as well. So the town clerk's function is really procedural and not one of substance.
Yeah.
Okay, so the modification to section 6 would say, title, final notification to complainant. Within, is the 5 days okay?
And those are business days, correct, right, based on the glossary?
Oh, good call.
Well, we have to decide what we're going to do, but yeah,
So within the glossary, it states that if
it's
the
5 business
member-
days.
Yeah, that's a good point. We should
Would you
probably.
want to add business days in there?
I think so. And then I think in case the town administrator is not present at that select board, that they should also get a written copy of that final notification. So the town clerk shall provide the town administrator and the complainant with a written statement of the decision, right? Don't we want
Well,
them
the
to get
select- the
record?
select- Okay, so,
In case he's not there, or she.
okay, just keep in mind that the final decision that we're talking about is going to be the letter from the select board that the town clerk is going to be mailing them a letter from the select board. Then she's not going to be writing the decision.
I just think in case that town administrator is not present at the select board, that they get a copy of the final decision for their records, right? Don't they need that?
Okay,
Yeah,
so
I mean, I would hope that the select board would.
this is a notification to the person that's aggrieved. The town administrator has access to that and would be following that, right, on your tickle board there?
So I think as a matter of this process, they would already be notified.
Yeah.
We just want to make sure the town administrator is notified. But I think
Yeah.
if it happens at a select board meeting, it's public record and.
Correct, yes.
Okay.
If I wasn't able to go or
Okay,
was
so if
there,
you're
I
not
would be
there-
able
That's what I mean.
to review the meeting minutes or the video and obviously reach out to the select board
Okay.
members.
So we've got it covered somewhere.
Okay,
it's
so we want the
implied.
town clerk to provide the
Okay.
complainant and the town administrator.
No.
Right, but we
We're
don't
saying
need
that
it.
that's already happened.
Okay.
We're assuming that that's already, that
we don't
happens as
need
part of
to-
the process.
We don't need, okay.
I don't think so. I was just asking the question if we needed it.
Thank you.
Yeah.
Yeah,
We know this town administrator would definitely, if he was absent, he would go and review the
exactly.
minutes, watch it on TV.
So thank you for putting the business days there because going back to the other one, it would be 30 business days, right?
No, well,
So
according-
that's why it's good to add that in there.
May not
According
be.
to the glossary,
Which we'll get to.
Which we'll get to. Let's not bring the glossary into this
Okay.
because
All right, yeah, you're good.
business days are defined in so many different, the state defines business in a statute, and the bottom line is, it's just, let's say 5 business days, because we're going to make a business day that makes sense. All right?
Okay.
but do we have to qualify the other days? So we refer to 30 days. So according to the glossary, that's 30 every days.
The written complaint shall be filed within 60 days of the alleged violation. So if they say in their complaint on January 1st, that's 60 days from January 1st. Okay, so there's no need to change 60 days by putting any other adjective in there, because they're going to know when the date of the violation is. All right? So that doesn't need to be changed. Within 30 days of receipt of the written complaint, when the town clerk gets it, right, they stamp it. And that will be the date of, so it'll be within
Yes.
30 days after that thing is stamped. Upon receipt of the response, the town select board shall have 30 days. So once they get the complaint,
Yes.
you know,
No, I
And-
think the point is whether the 30 is business days or actual days.
Actual.
They're actual days.
So the actual days.
30
Okay, so we're
days.
all right.
Yeah. And then, okay. So are we all set up with everything up to section 6? Are we all on board? Okay. Section 7 is really academic. It's just to let everybody know. This is under 6610 a public record. But just so that nobody has any doubts about it, when you're writing something on this, it's going to be a public record. Unless otherwise provided by the laws of the Commonwealth, which means that the records law gets modified from what it is now. All documents filed pursuant to this administrative resolution process, that's my attempt to make sure that it's the stare decisis is not in play here. Unless otherwise provided by the laws of the Commonwealth, all documents filed pursuant to this administrative resolution process shall be public records as defined in 6610. Anybody have any thoughts about that? Do you want to leave it there? Do you want to omit it? Do you want to change it? I suggest we should leave it, which is why I wrote it.
Well, I'll ask the question, is there any downside to leaving it there?
Downside to leaving it there? Yes.
What's the downside?
It's not in the spirit of the public records law. And court decisions generally look to the appearance of, is there a following of the law? And if it says it's in there, it makes it a heck of a lot easier for the court to say, if somebody says, I want this, and the town says, no, you can't have it.
The downside of removing it, but is there a downside of leaving it in, acknowledging that it's a public record?
No, I think it's good because we have people saying that we're not transparent.
Then we should keep it then.
Then I think we should.
The only downside I can see is going back to section 3, and this is a formatting issue, but, just the use of our numbers there, that's a lot of information, a small amount of information that takes up a lot of space just in a numbered format. And I don't know if that needs to be in a numbered format or it could just be in a paragraph form, but if it was in a paragraph form, we could almost get all this into one page instead of 2. And just thinking about the total length of this document, the more pages we can save, the better.
And I think you're absolutely right, my friend, but the problem I see for now in this is that we want somebody, there's a checklist. And if you have a paragraph, a checklist, they might leave out something. And I would hate to see somebody writing a letter complaining that the provisions of a charter, they're complaining that it wasn't followed in their case, and they leave something out and we send it back. You didn't give us enough information. This is a formatting thing which I find particularly useful when you're giving somebody, this is what I need you to do. You'll see most of my emails and stuff. But as far as getting on one page, I don't think that's, if we're starting to find out that we have a 250-page draft charter, that's all right.
Sure.
The charter that I've written has 88 pages, so that is below the average of charter, all right? We may get better, but let's worry about the length of how many pages it has, all right? You'll remember that Steve at one point said we're going to do it in 30, then he went to 50, and I made 88, but then again, I've got everything.
We can change the font size later on.
We'll change the font size.
Yep.
This is so,
Basic,
I use
single-
bold and
single
big
space.
font so I can see it.
Increase the
You get it.
margins.
We'll get it down to 1.
Every voter comes to the meeting, we're going to give them one of those little eyeglass things to enlarge it, make sure that they all can read it. Magnifying glass.
It's currently 12 Arial. We can go down to like 8.
Just remember that the people that do this, many of them, most of the activists, I think, are going to be, the senior citizens. And as one of them, I can tell you that there was a person that did tell me that they thought that whatever you do, I don't know what you're going to write, and I don't necessarily care, but whatever you do, make it so I can read it. Which I took to mean big font. But all right, are we satisfied then to say that we, at this point, accept with the modifications the outside section enforcement of the charter provisions draft? All right, so say you all. We have a vote. All those in favor?
Aye.
Hi.
All right.
And opposed? The ayes have it. that will be for our meeting minutes to be added as a document attached to the minutes. Hey, that's great. Now we have 2 articles that are done.
Not more.
Now, guys, the glossary is a pain in the neck. It's 1837. We're going to end at 1845. We are not going to finish, but we could start the definitions. Does anybody want to go into the definitions now, or do you want to go into the 3rd item on there and save the definitions for the next? Any thoughts on
Third item being,
the 3rd item, the exercise of legislative powers?
I was wondering about our next, our setting up our committee meetings for the rest of the year, or if we want to do that.
Right. All right, so then shall we stop there as far as reviewing? I thought we did a good job on that one. And go into the discussing and deciding our meetings for November and December. And we will table glossary definitions and exercises of powers for the next meeting, whatever that may be. Okay, one of the things I suggest, and we know that we're in November, we have a Thanksgiving and all the things, we have shopping for Christmas, we have Christmas and Hanukkah in December, so we are be lucky if we can get some meetings in. I would still hope we could get 2. One of the options that we have is to do our normal, meetings. One of the options we have is to have longer meetings, subject to availability of the room and your ability to attend and all that. I think it's very important that we have all of us present when we're going through legislative articles. So does anybody have any thoughts how we can accommodate, let's start saying at least 2 meetings. So we have 1 more meeting at least in November and 2 meetings in December.
So I'll say I could do the 17th, but that's the only one left in November that I would be present for. I'm not here on the 24th.
So our next meeting would be the 17th from your purpose, 7 days from now?
I works for me, I'm just saying. I'm throwing that out there as a
And that's a Monday?
Monday.
Yep.
Okay. With respect to that, Paul, 17th?
I can do the 17th.
Gary?
I am available that day. I'm going to wonder, though, whether we can, if our goal is going to be to at least finish the 2 that are on the table, do we have a little bit more time that we can add on to that meeting before we call it a month?
Okay, the 17th is a meeting, if we started it here, but I don't believe there's a select board meeting on the 17th.
There is not.
Correct.
Okay, so that means we could do here an hour and a half, or an hour and 15 minutes, or 2 hours.
I'm just.
Does anybody
Aim to
have any?
bang
Well,
out
let's.
the rest of that. Yeah,
Chuck, is
I think that's a
17th
good
work for
idea.
you?
It works for me.
It works for, we'll make it work. Is everybody willing, since there's nobody in back behind us waiting for us to get out of here? Is it possible to do, say, from,
I think like 90 minutes, plan on a longer, 2-hour max, but, try and.
okay. Okay, so we'll say a 90-minute. Instead of having an hour, we'll have 60 minutes, we'll have, and the start time,
So-
is 5:45 still good?
Until 7:15?
Okay?
Okay.
Does that, I know some people struggle to get here at 5:45. Should we start
want 'em.
at 6? I know you're childcare.
It's fine, it's not gonna
Doesn't matter, okay.
be the same difference, probably. Thank you.
And I don't want anybody to think that, if you're 5 minutes late or anything like that. I mean, you were kind enough to give us a heads up, and I twiddled my thumbs for all of 30 seconds. You were here. It's not, starting time is when we can do it. I'm more in wanting to have everybody here to discuss rather than just beginning something.
Yeah, I mean, I could definitely do the 1st, December 1st also. I mean, if we were looking into December, you
Yep.
want to do the rest of the year, right?
Right,
So we
yeah.
have,
we could throw in, I think us kind of front-loading this calendar on 1 or 2 days a week if we could. eliminates the need for this to go so long in 2026. So
Okay, let me just ask you,
better to do
Megan,
that.
before, are we all agreed of a 90-minute meeting on the 17th of November?
Yes.
Okay, so now we're into December. And what are you suggesting we do in December, Megan?
I would say the 1st.
That's the special town meeting date?
Oh, good call.
Yes.
That wouldn't work.
That's at Anna Maria, right?
Yes, it is.
See, December, yeah, December's gonna be tricky. Might need to be flexible in December. If we're looking at a Monday, the 15th.
Well, we don't got any day, I mean,
Yeah.
everything is subject to availability. I mean, there are some, the cable people tell me that there's afternoon times available, but I don't.
Yeah, that won't
I mean,
work.
that's what we're all
So
trying to do.
why don't we bring our calendars with us on the 17th and see how creative that we can be
Okay.
for December?
And meanwhile, everybody can have time to check.
Yeah.
Sure.
All right, so we have our next meeting is going to be a week from now on the 17th, and starting at our regular time.
Yes.
Okay. We have decided our November meeting, we're going to punt till next meeting, so when and with time, brief committee comments, remarks from the members present. I'm excited to say that we're going to be presenting a little bit of a report to the select board. They've been given an advanced copy of basically what we're going to say. We'll be more interested in, just basically hearing if they have anything they want to say to us at this point, and going from there. Does anybody have anything they want to say about that or anything else in the few minutes that we have remaining?
Not about that, but I think that the way we're doing it for right now, with making the changes live, as Chuck is doing it, I think it actually works well. And if we can figure out a way to move this process along, I think we'll have a good outcome. So, happy about that.
I appreciate that. Megan, anything else? Anything?
No, I mean, as we go through this, I don't think we need to spend too much rereading it out loud, but maybe we talk and do the discussion. That might cut down a little more time,
Okay.
because we all have it. We have it printed, and we've already hopefully pre-read it, so it might be easier just to go right into discussion versus reading.
I'm just trying to make sure that the record is clear. But be that as it may, if we do make a change, somebody that's listening to us, either, here or on the TV or whatever like that, they're not going to have a copy before them. So that's why I'm suggesting that,
Oh, I see.
limited amount of that.
Okay.
And like the stare decisis, if, they were to immediately say, what the heck are they talking about? But that's just my insight. I mean, I'm open to interpretation
Okay.
or, guidance, but that's the reason I do it, and I probably will not, I'll try to cut back on it, but I still think it's an important part of
Okay.
what we're doing. Because remember, we're trying to be transparent to a lot of people. Anything else, Chuck?
No.
Gary?
All good.
I'll entertain a motion.
Motion to
To
adjourn.
adjourn. Second.
All those in favor?
Aye.
Aye.
We are adjourned. Thank you very much. And now comes the fun part.
I think so, yeah.